In this lecture, we are going to complete our, or finish, I should say, our exploration of Chapter 6, which is titled Privacy in the Government. And in particular, we are going to talk about Section 6.10 and Section 6.11. All right, Section 6.10 is titled Information Dissemination. So we are now going to consider the information dissemination category of Solov's taxonomy. After we survey 3 federal laws that restrict the dissemination of personal information that organizations have collected, we will discuss the Freedom of Information Act, designed to promote open government by allowing news organizations and private citizens to access records maintained by federal agencies. We will also explore how information collected by the government for one purpose, such as collecting tolls, is being used as evidence of people's whereabouts in both criminal and civil cases. And finally, we will summarize an important U.S. Supreme Court decision limiting police access to cell phone records. The Family Education Rights and Privacy Act, or FERPA, provides students 18 years of age and older the right to review their educational records and to request changes to records that contain erroneous information. Students also have the right to prevent information in these records from being released without their permission, except under certain circumstances. For students under the age of 18, these rights are held by their parents or guardians. FERPA applies to all educational institutions that receive funds from the U.S. Department of Education. In 1988, President Ronald Reagan nominated Judge Robert Bork to the U.S. Supreme Court. Bork was a noted conservative, and his nomination was controversial. A Washington, D.C. video store provided a list of Bork's video rental records to a reporter for the Washington City paper, which then published that list. While the intention of the paper was most likely to embarrass Bork, it also had the effect of prompting Congress to pass the Video Privacy Protection Act of 1988. According to this law, video providers, including providers of online videos, cannot disclose rental records without the written consent of the customer. In addition, organizations must destroy personally identifiable information about rentals within a year of the date when this information is no longer needed for the purpose for which it was collected. As part of the Health Insurance Portability and Accountability Act of 1996, Congress directed the Department of Health and Human Services, or HHS, to come up with guidelines for protecting the privacy of patients. These guidelines went into effect in April of 2003. They limit how doctors, hospitals, pharmacies, and insurance companies can use medical information collected from patients. The regulations attempt to limit the exchange of information among healthcare providers to that information that is necessary to care for the patient. They forbid healthcare providers from releasing information to life insurance companies, banks, or other businesses without specific signed authorization from the person being treated. Healthcare providers must provide their patients with a notice describing how they use the information they gather, and patients have the right to see their medical records and to request corrections to errors they find in those records. The Freedom of Information Act is a law designed to ensure that the public has access to U.S. government records. It was signed into law by President Johnson in 1966 and it applies only to the executive branch of the federal government, not the legislative or judicial branches. The Act carries a presumption that the government will release the requested records. If an agency does not disclose records, it must explain why the information is being withheld. And there are 9 exemptions in the Freedom of Information Act, spelling out those situations in which the government may legitimately withhold information. So, for example, a document may be withheld if it has been classified as secret for national defense or foreign policy reasons. The government may withhold the release of documents containing trade secrets or confidential, commercial, or financial information. Another exemption deals with documents related to law enforcement investigations. The E-ZPass is an automatic toll collection system used on most toll roads, bridges, and tunnels between Illinois and Maine. Drivers who have installed an E-ZPass tag, which is an RFID transponder, in their vehicles are able to pass through toll booths without stopping to pay an attendant. Instead, an E-ZPass reader installed in the automated toll lane gets information from the tags of the cars that pass through and simply deducts the appropriate toll from each driver's account. However, states do maintain records of when cars pass through toll booths, and most of the states in the E-ZPass network provide information in response to court orders in criminal and civil cases. A well-known example is the case of Melanie McGuire, who was a New Jersey nurse suspected of murdering her husband and throwing his dismembered corpse into Chesapeake Bay. To help prove their case against McGuire, prosecutors used E-ZPass records to reconstruct her movements. E-ZPass records have also played a role in divorce cases by providing evidence of infidelity. In 2010 through 2011, a series of 9 armed robberies occurred at Radio Shack and T-Mobile stores in the Detroit area. In each case, the robbers made off with sacks of cell phones. The police arrested 4 suspects in 2011. One of them confessed to the robberies, named his accomplices, and provided the FBI with the cell phone numbers of some of them. Based on this information, the prosecutors sought court orders under the Stored Communications Act to obtain the cell phone records of Timothy Carpenter. The Stored Communications Act simply requires prosecutors to show that it is reasonable to believe the requested information is relevant to their investigation. That is an easier standard to meet than the demonstration of probable cause needed to get a search warrant. Federal magistrate judges approved the orders, and 2 wireless providers supplied 127 days of cell phone location records for Carpenter, 12,898 location points in all, averaging 101 data points per day. Prosecutors ended up charging Carpenter with 6 counts of robbery and 6 counts of carrying a firearm during a federal crime of violence. Carpenter's lawyer moved to suppress the evidence provided by the wireless carriers, arguing that the government's seizure of these records without a search warrant violated the 4th Amendment to the U.S. Constitution. The district court denied the motion because of the third-party doctrine, which holds that people should not expect that information voluntarily given to third parties will be kept private. In this case, the wireless carriers were the third parties maintaining the location information from Carpenter's cell phones. During the trial, witnesses testified that Carpenter was the mastermind behind the robberies, planning them, supplying the guns, and serving as the lookout. Prosecutors used the location information obtained by the wireless carriers to provide additional evidence that placed Carpenter at the scene of 4 of the robberies. Carpenter was found guilty on nearly all counts and was sentenced to more than 100 years in prison. Carpenter's case went all the way to the U.S. Supreme Court, which in June of 2018 ruled 5-4 that the prosecutors had erred in mechanically applying the third party doctrine to this case. According to the majority opinion written by Chief Justice Roberts, cell phone location information is not truly shared as the term is normally understood. Therefore, the prosecutors did violate the Fourth Amendment when they seized Carpenter's cell phone records without a search warrant. The opinion noted wireless carriers are continually logging location information for all 400 million cell phones in the United States, not just those belonging to suspects in criminal investigations. So this is what they said. The U.S. Supreme Court, we hold that an individual maintains a legitimate expectation of privacy in the record of his physical movements as captured through cell site location information. The location information obtained from Carpenter's wireless carriers was the product of a search. Okay, final section here, section 6.11, titled Invasion. So early in chapter 5, we describe privacy as a zone of inaccessibility. People have information privacy to the extent that they have some control over who has access to their personal information. In quite a few modern situations, people may have very little control, and they must cede access to their personal information if they wish to use the service provided. If the loss of control is accompanied by a loss of mental tranquility or interferes with someone's freedom of decision making, that is a privacy invasion according to Solov. So we're going to begin this section by giving 2 examples of government actions to prevent invasion, and then move on to survey 2 government actions that can be seen as invasive. So after being sworn in as chairman of the Federal Trade Commission, or the FTC, in 2001, Timothy Murris looked for an action that the FTC could take to protect the privacy of Americans. And it didn't take long for the FTC to focus on telemarketing. Responding to the desire for greater privacy, the FTC created the National Do Not Call Registry, which is a free service that allows people who do not wish to receive telemarketing calls to register their phone numbers. The public reacted enthusiastically to the availability of the Do Not Call registry by registering more than 50 million phone numbers before it even took effect in October of 2003. The Do Not Call registry unfortunately has not eliminated 100% of unwanted solicitations. The regulations exempt political organizations, charities, and organizations conducting telephone surveys. Even if your phone number has been registered, you may still receive phone calls from companies with which you have done business with in the past 18 months. So the creation of the registry is a good example of how privacy is seen as a prudential right. The benefit of shielding people from telemarketers is judged to be greater than the harm caused by putting limits on telephone advertising. Television watchers complained to the Federal Communications Commission, the FCC, about loud commercials for 50 years. The Commercial Advertisement Loudness Mitigation Act, or the CALM Act, signed into law by President Barack Obama in December of 2010, required the Federal Communications Commission to ensure that television commercials are played at the same volume as the programs they are interrupting. In an effort to curb the illegal production of methamphetamine, or meth, federal and state governments have passed laws limiting access to products containing pseudoephedrine, which is used in the manufacture of meth. The Combat Methamphetamine Epidemic Act limits the quantity of pseudoephedrine that an individual can purchase in a month. Whether the laws have been effective is a matter of debate. In most states, original Sudafed is still sold behind the counter to adults, but they must show an identification card and fill out a sales log with their name, address, and signature. Two states, Oregon and Mississippi, require a prescription to acquire a product containing pseudoephedrine. In several well publicized cases, grandparents purchasing cold medicine for members of their families have been arrested by police for exceeding limits set on pseudoephedrine purchases. In an effort to provide enhanced passenger security at airports, the Transportation Security Administration began deploying advanced imaging technology, or AIT scanners, in 2007. Some people were offended at the images produced by the AIT scanners, which reveal all anatomical features. Lawyers for the American Civil Liberties Union called the AIT scan a virtual strip search. In 2010, the Electronic Privacy Information Center filed a lawsuit to suspend the deployment of AIT systems pending further review. Epic called the program unlawful, invasive, and ineffective, arguing that it violated the Privacy Act, the Religious Freedom Restoration Act, and the Fourth Amendment to the Constitution. And in February 2011, the Transportation Security Administration, or the TSA, announced that it was about to begin testing new software on its advanced imaging technology machines that would eliminate passenger-specific images. The tests ended up being successful, and in January of 2013, the TSA announced that all body scanners producing passenger-specific images would be removed from airport checkpoints by June of 2013.